Now we have we did the shipping, and I think we had very, very interesting panel. Now we pass to the law, but it's still the law of the shipping. And I will call, I think, the moderator with my friend Federico Deodato on the podium, who will co-moderate with me the panel. And I will call Jonathan Lux, Mario Riccomagno, James Bean, David Pitlarge, Mark Clough, and Valeria Novella, who should have been the previous panel. I mean, she's very young, but she has been president of the Young Ship Owners 2 presidents ago, before Giacomo and Andrea. She's biologically very young, but in some way she will now face the challenge from the law, from the point of view of the user of the maritime law. So I will ask Valeria, who had a phone call for a shipping matter, as in our business this can happen very often, to comment and perhaps help Federico and myself at the end to put some questions from the side of the ship owners. So please come, join us. Valeria, where would you like to sit? I think next to Federico is. Or Mario, and I sit here, yes. Oh, you sit here, and I sit there, okay? So, hello? Yeah. Okay. I think we will not introduce longly the panelists, because I think they are well known, but I think the first of them is James Bean. He's presently the head of the Standard P&I Club, but I had the pleasure of working along with him on some cases, not in a too distant past, and so I know also what a good lawyer he can be. And I will leave to Federico the introduction and the question to James.
Microphone? Is it working? Yeah, good. So thank you very much, Francesco, for being here. I'm sorry, I have to apologize. In the last couple of years, I couldn't attend. You know why? We had a little bit of an issue. So here I am again. I have my own punishment, which means I'm surrounded by lawyers. I don't know what the hell I'm doing here, but that's my punishment. Thank you very much, Francesco, to be in this particular panel surrounded by brilliant lawyers. So I will probably not understand the majority of what you're going to say, but that's fine. I've been able to negotiate with Francesco that I had my own, as discussed yesterday, port of refuge, and that is James. James is going to be asked something which is not specifically shipping law. It's more an introduction to the challenges which we are going to see as we're talking of the future. Future is today. Now it's better. And one of the things is ITs What is happening in shipping in respect of ITs? We are hearing every day or reading every day of how much influence the new ITs, the new technologies are going to become more and more important in shipping. I think everybody has heard of the, what's wrong? What's wrong? Has heard of this idea of...
Try this.
Nice, good. And we have all heard of semi-autonomous ships, autonomous ships. Is it going to happen? Is it not going to happen? We don't know, but definitely there will be something which is going to go in that direction. So the IT issues and related issues, which may be insurance issues, which say what's going to happen with this stronger and stronger, say, presence of IT-related issues, which we are going to see. And clearly don't know, say, if there will be legal issues, which you can introduce, and then perhaps it will become something which we can discuss with our esteemed other panelists, okay? James, what's happening with these autonomous ships? Is it a worry for an underwriter? What are you doing?
Well, thank you, Francesco, and thank you, Federico, for the kind opportunity to come and speak to you all today. Actually, I feel I should be segueing almost the previous discussion because Federico's asked a very broad and wide-ranging question, actually, which I will try to answer. But I think first up, from my own personal and professional perspective, the earlier discussion, and I must applaud the panelists for the breadth of topics covered and the importance of the issues that they raise within this industry. First of all, the importance of promoting women within shipping, but linked to that, encouraging the younger generation to be passionate and interested in the world of shipping. Insurance was once described to me by a colleague as the drunk uncle at the party. You know, you're obliged to invite him there. You know, you kind of hope he doesn't make a fool of himself, but you know, once in a while he's useful. And having myself made the transition from law to insurance, I find that's a little unfair. Lauro sort of introduced the fact that she was trying to describe to her friends in Parma the fact that, you know, she's in shipping and you get that blank look. Well, the same is true in insurance, and I think it's incumbent on all of us to bring insurance to life, to encourage the next generation in, because the next generation, in encouraging a diverse and more inclusive workforce, they are the individuals that are going to be driving this industry forward, whether it's from a shipping perspective or from an insurance perspective. And that really leads me into the topic that I'd like to talk on today, which is technology in shipping. I see, and as was touched on in previous panels, you know, we're at the edge of an exponential increase in technology in shipping. Whether it's disruptive to our business, whether it's going to give rise to new challenges, without question, yes. From a Standard Club's perspective, and I think it's true for all these panelists here alongside me, the brilliant lawyers, I must say, it's the first time I've ever been put in that category. But alongside these brilliant legal minds is that as providers of service to the insurance industry, as providers of service to the shipping industry, we are all obliged to keep up with the technological developments that are happening. Now, I'm pleased to say I can't profess to be an expert in all things technological, but one of the things that we have done at the Standard Club is very early on we set up a technological working group. I'm the oldest member of that group. It consists of guys and girls from the claims and underwriting team, loss prevention and IT. And their watching brief was to advise and report to the management team on what the technological changes are in shipping and how, as insurers, we can keep up to date with that and tailor the product and offering that we provide to the industry. And really, within that, it's such a broad range of topics, but there are three things that I was hoping to touch upon today. That is, first up, automation. The second is blockchain, and it's a word that's often bandied around, but I want to try and describe and put into real life what that means from an insurer's perspective. And the third is in relation to data. Now, clearly, from an automation perspective, there are different and varying ranges of automation. And you know, from an insurer's perspective, the reality is ship owners are starting to experiment already. Regardless of what we may think, there are owners out there who come 5 or 10, 15 years' time will have fully automated vessels that as insurers that we've got to be able to insure and that we've got to be able to understand, whether it's from a loss prevention or whether it's from a rating perspective. And needless to say, automation gives rise to lots of challenging legal questions, whether it's in relation to collision, whether it's in relation to the interface between human and ship. I don't think we've got enough time to really touch on those, but that's a sort of 10 to 15-year horizon. Where I see technology impacting upon insurance in my sector in a much nearer space of time is really in relation to blockchain. Now, blockchain, it's often talked about, and I really don't pretend to understand it, save for the fact it's a shared ledger of information. So if you all are parties to let's say, probably the best analogy is in relation to bills of lading. If you have the shipper, you have the receiver, the bank, and the ship owner all sharing the same information, you're able to reduce the friction in the passage of information from one party to the other. Now, it does so because blockchain works on the basis that you all share the same information. That information is held remotely, it's secure, it's safe, and you can only ever change it with the agreement of all the other parties in that chain. Now, where I see that intersecting with insurance, and actually we have a very real-life example of that, is that we are starting to see the likes of Maersk requiring their ship owners to be part of a blockchain. In other words, they provide real-time live information to their insurer about their vessels. It could be through data that's collected from on board the ship, but also it's in relation to where the ship is located, what is happening, what is being carried. All of that requires and demands that the insurer, by receiving that information, is able to tailor the price of the insurance that they provide to Maersk. And that's ultimately what they're looking to achieve. It's a tailored insurance product. Within the world of P&I, we provide blanket cover. It's 365 days a year, wherever you are in the world. But I can increasingly see, and we're already having demands upon us from other owners, that in the next 12 to 36 months, we're going to be obliged to start tailoring our insurances. Why? Well, owners want to be able to demonstrate that their risk profile is better than other owners, and that by sharing that information, they can drive down costs. But secondly, and more important, or just as importantly, is ease of flow of information. If you're dealing with everything on an electronic platform, you don't have the issues that you have to send emails, you don't have to have people processing documentation, you don't have to wait until you receive your debit note or credit note. All of that will be done seamlessly in an electronic environment. And that's really where I start to see blockchain interfacing. Now, from a legal perspective, and again, I turn to my esteemed colleagues on the panel, but that also gives rise to challenges around jurisdiction, around apportionment of liability, and actually not many jurisdictions are ready for this technology, but one thing is, from an insurer's perspective, I firmly feel that we have to be. The third and probably final point in relation to technology is demands upon the data that we as insurers have. Now, the Standard Club insures 10% of the world fleet. Within the international group, we insure 95% of the world fleet. Yet, do the clubs share information between one another? Very limited. And given the power of the information that we have, or the amount of information we have, I feel it's incumbent upon international group clubs to share that information on an anonymized basis. Why? Well, we should be looking at ways in which we can drive down premium for ship owners by having that information, allowing us to better assess and evaluate risk. We're able to better support ship owners. But also, if we're not doing it, someone else will be. And I think it's very easy to sit here and assume that, within the international club with high limits of cover, I think, Tradewinds quite aptly describes it as a cartel, that we're insulated. Well, the reality is we aren't. And if we don't innovate, and if we don't embrace this technology now, and we have to do it now, then I think, it puts all of our livelihoods at risk. And it's important as a service provider to the shipping industry that we stay relevant and we're here for the future.
Thank you very much, James. And this is, I think, in a way, dovetailing also with what, say, the younger ship owners were mentioning before. There was this discussion on, say, exchange of information, communications, and so on, which is a reality. The reality is that today, the amount of information which is available is huge. The thing is putting all together in the same place and make it available. And that is something which I'm sure will be a challenge which they will have to face. I don't think it's going to be your time or my time when we are going to see these big changes. Blockchain is taking up, but say, it will take years before it actually spreads out to its full potential and so on. That's another I think, challenge for whoever is going to be in this business going forward. So thank you very much. And then if anybody has any questions on what James was saying, then perhaps we do it at the end of the first tour. Francesco?
Oh, thank you, Federico. Thank you, James. Now we pass, I think you are all the members of the crew of Shipping and the Law, but we have a new member that is Mario Riccomagno, and I would like to give just a little bit more of time to Mario because among the other things in his life, he devoted a lot of his effort to arbitration. We had in the past edition 3 presidents of London Maritime Arbitrators Association, Bruce Harris, Clive Aston, who came many times, and Chris Moss. So I think I would like to ask Mario, who is an international man, as a member of CMI, but also a very respectable Italian lawyer, if perhaps the concept of arbitration, in particular commercial and shipping arbitration, connected to a single country like for instance, arbitration, LMA arbitrations or other type of London arbitrations, can give the place to a sort of wider community of people who trust themselves and obviously trust also the Court of Appeals that should perhaps judge the decision in the awards of the arbitrators. But I leave the floor to Mario, who will talk about these things, hoping in the next, the 10th edition of the Shipping and the Law, to have a full section dedicated to arbitration. Thank you.
No.
Thank you, Francesco,
No.
first of all, for inviting me. Can you hear? Sorry. Thank you, Francesco, first of all, for inviting me to attend this conference. It is a very good formula. I congratulate with you because it is a very simple and colloquial way for discussing hot topics on shipping in general, and also to have this mixed formula of having ship owners, operators of the shipping trade, together with lawyers as well. I think that conventions having only lawyers, they can be perhaps too much far away from the reality sometimes, and so this is a very good example. Speaking about arbitration, as which is my topic of today, arbitration in the shipping trade is a notion which should be considered under the general view of the international commercial arbitration. International commercial arbitration is the best way, in terms of best, I mean the more simple way to try to accommodate the disputes. Disputes are part of the trade, as a matter of fact. They have also a cost in terms of image of the companies, in terms of money, and in terms also of relationships between the parties of that dispute. So international commercial arbitration is the best way to accommodate the disputes which have a transborder nature. In other way, the disputes which can somehow have parties of different countries which relates to trades in different jurisdictions of areas of the world, and they have a very substantial clash between cultures, as a matter of fact. Try to imagine a litigation between an Italian company and a US company, where there are two councils coming, one from the so-called continental civil law and the other one from common law. Common law lawyers are accustomed to cross-examination, for instance, for collecting the witnesses' depositions. The continental lawyers instead are not accustomed to at all to the direct way under which the cross-examination is conducted, and they are accustomed to a much more formal way for collecting the position. This can give a very distant way for disputing, and if there are international arbitrators prepared to accommodate this kind of disputes, taking something from the common law world and some from the civil law world, in terms also of procedural aspects, this is the only possible way for trying to solve the disputes. So this is the international commercial arbitration pattern. Maritime arbitration has its own specificity within this general trend of the international commercial arbitration. But basically, it takes some basics from the international commercial arbitration as such. Of course, must be much more in line with what is the shipping trade, which is a shipping which is per se international and is a trade which is based on what the French call the droit formulaire. In other words, is much more based on customs of trade, on the contractual aspects, much more than the enacted state laws. With this specificity, the shipping lawyers, the shipping council, has to do their daily business. Now, historically, there have been some attempts to try to unify some way the world of the shipping arbitration in a general context. Taking it that there are in the world approximately 20 maritime arbitration centers, so devoted only to the management of the disputes concerning the shipping trade, and taking also the view that some of the major institutional courts of arbitration, like ICC, London Court of International Arbitration, AAA in New York, Singapore, Hong Kong, and also Tokyo as well, they are having special parts of their special department dealing with shipping law. The idea was whether it was possible somehow to make these rules of the arbitration and the practice of these arbitration centers much more close each other. Attempts were made in the 96 and the 97 in the area of ICMA, International Congress of Maritime Arbitrators, which was a center which was created by the well-known arbitrator Cedric Berkeley in the 70s. And that attempt, together with another attempt which has been conducted by the ICC together with CMI, which had enacted the rules of ICC, CMI, but were not functioning very well, to try to make them more modern and somehow. After various studies that have been made worldwide between the single nations and in particular the CMI member states, has led to a conclusion that London is the place where maritime arbitration is conducted with which leads the cases, because they have a very great number of cases in comparison with the others. London make the users of the arbitration not completely happy, but at the moment there are no particular other centers that can replace London as such. Also, CMI more recently has set up a working group on maritime arbitration, not with the idea of having a court of arbitration within the CMI, which should be inconsistent with the scope of the CMI as such, but to have a place where information could be given to all those having to deal with maritime arbitration, and so to make them having more knowledge of this way of settling the disputes. However, even this attempt, which was made in CMI, and it was an attempt which commenced in 2015 after 2 years of study, ended with a resolution by the General Assembly saying that it was no point for CMI to invest in this project. So the situation at international level through these institutional centers was not successful, as a matter of fact, but the maritime arbitration is a reality. It needs, in any case, to be considered and studied to function in a better way. Shall we consider that maritime arbitration now has also to face the other, I don't call it challenge because it is not a challenge, but the other way of settling the disputes coming from a mediation. Mediation is a much more simple way to settle amicably the disputes. It is enormously less costly. However, what happens when the mediation fails? There is no other possibility other than to go to courts or to go to arbitration. Yes, so I think that I have answered to your question today, for this moment, and after you.
Thank you very much, Mario. I know we discussed this matter in more detail, but I think that next year with other colleagues, we should have a full section dedicated. Perhaps I was thinking of a longer section to arbitration and perhaps mediation. And I thank you also because I think you now introduced the questions that Federico would like to make to Jonathan Lux.
Absolutely, Sam, because here we started talking about, we are users, okay? So from time to time it's difficult for us to understand some of the subtlety of choosing an arbitration rather than a mediation, or selecting to go in court and so on. Mediation, it's obviously coming from the past. There was an issue in between somebody, you were going to the wise man, and the wise man was sorting it out. Arbitration is, instead of being the wise man, you are going to the council of the wise men, and you have to sort it out possibly quickly. Otherwise, you had to go to the king or to the boss of the tribe and sort it out, which is going in court today for me. Arbitrators, we have heard what Mario had to say. On mediation, try to give us a little bit of an idea of why it is different, or possibly a better choice for two parties in dispute to go to mediation rather than to arbitration. And then I will ask the same question, possibly, insofar as going to court as an alternative, as you were saying. We users of, say, the system can we be advised on the difference, on the time it takes to resolve possibly a litigation following one of the three alternatives, and costs, which are another important thing when you have to discuss about these things. I leave it to you. Who wants to start first on giving this small recap for us users?
Thank you. I'm happy to respond to the invitation. Good morning, ladies and gentlemen. Let me start by thanking Francesco and his excellent team for their wonderful hospitality. Mario has spoken eloquently about arbitration. I'll look at dispute resolution a little more widely, conscious of the title of this session. Also have in mind the future, but to look at the future, you need to bear in mind the past. And perhaps I could just start with a quote from US Supreme Court Chief Justice Warren Burger about 40 years ago. And he said this: "The existing judicial system is too costly, too painful, too destructive, too inefficient for a truly civilized people. Reliance on the adversarial process as the principal means of resolving disputes is a mistake that must be corrected. For some disputes, trials will be the only means, but for many claims, trial by adversarial contest must in time go the way of the ancient trial by battle and blood." Now, what's he referring to there? This isn't a joke. Something over 100 years ago, in fact, the norm in the UK was trial by battle. And that evolved into trial by the king or queen personally administering justice, traveling throughout the country. And that is the reason, by the way, that the biggest division of the High Court of Justice in London is known as the Queen's Bench Division, because it is the Queen's judges who administer justice. Slow, expensive, problematic. All of us know some of the issues with litigation. So arbitration was spawned as perhaps the first form of alternative dispute resolution. Indeed, I belong to a club known as the Mafia, which stands, my club defines the Mafia as more arbitration for international arbitrators. But the problem with arbitration, some would say, is that it has also, over time, become over-lawyered and therefore suffers the same problems of delay and expense as the litigation process. Indeed, one High Court judge in London described arbitration as unwigged court proceedings, because we arbitrators, maybe some of us should, but we don't wear wigs, whereas the judges, of course, do. So arbitration doesn't satisfy the requirements for speed and cost effectiveness, certainly for smaller disputes. And in the United States, probably about 40 years ago, about the time that the quote that I started off by reading was uttered, there was a move in the United States for ADR, alternative dispute resolution, or defined by many lawyers as alarming drop in revenue, because it serves in enabling disputes to be settled in a fraction of the time that would be taken in court or arbitration. Now, Mario perfectly fairly said that a problem with mediation is that it is not guaranteed to secure a settlement, and that is perfectly correct. But the best available data in the UK, published by the biggest ADR provider in the UK, which has also offices around the world, called CEDA, the Centre for Effective Dispute Resolution. They carry out a biennial audit, and their data suggests that something approaching 90% of mediations are successful. Of course, it depends how you define success, but I'm assuming that means either a complete or partial settlement of the matters in issue. So just a few words, if I may, on mediation, why to mediate and when to mediate. And please do tell me if I'm running out of time or if
It's okay.
preferably with a minute or two's notice.
Francesco, you're in charge of that.
So just to explain the key difference between mediation on the one hand and arbitration or litigation on the other hand, and the best story I know for this purpose involves an orange, or because we're a shipping audience, let's call it a shipment. I have to enunciate that very carefully. A shipment of oranges. So this side of the room says the oranges are their oranges, and the other side says, no, it's our oranges. What could a judge or arbitrator do? The judge or arbitrator would make a decision and say the oranges go to the claimants, or the oranges go to the respondents, or in an unusual case may say 50-50, or I guess in a corrupt system may say, thanks very much, I'll take the oranges. But those broadly are the choices. Now, if the matter goes to mediation, the mediator is not making any decision, is the first point. The mediator is trying to drill down and explore interests and needs as opposed to the positions and rights, which are what are an issue in court or arbitration. So the skilled mediator discovers that this side of the room needs the fruit of the orange to make orange juice, and this side of the room needs the skin, the rind, to make marmalade. So in fact, both their interests can be catered for from the same orange or shipment of oranges. Now, I have to say, having conducted quite a few mediations, it's rather unusual to find the parties' interests aligning quite so neatly, but I hope that illustrates the difference between the two processes. So briefly on why to mediate and when to mediate. I think there are four key factors. The first two really go hand in hand, and that is speed and cost. The 80-20 rule steps in. It was an American lawyer friend, I don't know how empirical the research was, but who said to me, you know, in the average case, 20% of the time and cost is spent acquiring 80% of the necessary evidence, and it follows that the balance of 80% is spent on the remaining 20%, which is not a very economic model. And so the ideal with mediation would be to mediate at the stage where, or perhaps even slightly prior to the time when you've acquired that 80% of the evidence, when you've spent perhaps 20% or less of the overall cost. So time and cost advantages. A third advantage is innovative solutions. Now, you saw it with the orange. No judge would have had the power to say, okay, you'll get the fruit and you'll get the rind. That would not have been a possible outcome in court or arbitration, but it is something that can be a part of a settlement arrived at in a mediation. And I could, perhaps later if time permits, give you an example, a real-life shipping example, which would bring that point more to life. But I'll leave that till later.
Thank you, Jonathan. I think the fourth and the next question will be done in the 10th edition of Shipping and the Law. Okay. But just a quick one, because I know you are like me, very young in your spirit and very enthusiastic. As a mediator, are you happy when an agreement, a solution is found, or are you trying to, as much as you can, not to find whatsoever agreement, whatsoever settlement, but a fair settlement? You have to reply with one, maximum 2 sentences, please.
I can't necessarily assess the overall fairness of the settlement, given that I've only got a fraction of the information and documentation that the parties and their lawyers will have. I only have what they chose to put before me. Settlement is the desired outcome, but it's not my job to force the parties into a settlement.
Okay, thank you very much. Perhaps we will have a small section on mediation in our arbitration conference next year. David, I think this time I always ask you a very hot subject. And, I don't know if arrest of vessels is a hot subject. I think, I suspect you may want to speak about UK arrest of vessels, which is these days very common also because the next section we will see how loans are traded between banks and other financial institutions. And I think that arrest of a vessel may be one step that is going to happen in this very painful process. And perhaps the arresting party is not always right. You may have some wrongful arrest. I think this is about what you are going to talk to us. So.
Thank you, Francesco. You've raised the bar just a little bit. I was already feeling a little bit like an intruder when thinking about how I'm going to shoehorn a subject which is based on principles established in the Elizabethan era, reaching their maturity about 160 years ago under the heading, "The Future is Now." I now have to make it hot as well, which is even harder. There is topicality, though, and with the contrivance, say, of a 70s DJ, I can make the two work. There has been a debate which has been rumbling on for some time and has been postponed both in the courts and at the institutional level. And as it happens, those will be aired in the Court of Appeal on the 6th of November and at the CMI conference on the 9th of November in London. So I can claim topicality, and as that long-awaited debate is about to happen, the future in that respect is now. Whether it's hot or not, let's see. Topicality, briefly, the reason I wish to just touch on that is it's very important to me. We represent the owners of a vessel called the Alcyon, which, as the Admiralty judge recently remarked, was the first a vessel which raises important questions of arrest for the first time in 30 years. The judge willingly gave leave to appeal. The Court of Appeal gave leave to hear that appeal on an expedited basis. As I say, we're working towards that in the coming weeks. Along with that, we had a recent strong visitation from the Italian Maritime Law Institute, who participated in an excellent seminar at James's office, where one of our leading lawyers, a former judge, indeed a former participant of shipping in the law, Sir Bernard Eder, gave a powerful paper on why the English law needs to change. As I say, it's coming up before the CMI, and I think there, as an echo of the splendid tribute yesterday to Francesco Berlingueri, it is the sort of comparative law issue which was so important to him and which he felt could be shaped by the community of lawyers, which I think your conference so splendidly represents, Francesco. As a further footnote in honor of Francesco Berlingueri, it's interesting that in a leading High Court judgment by on the bench, the leading Admiralty jurist, he cited Francesco's magnus opus, The Arrest of Ships, recently. Finally, in terms of topicality, I think there's a zeitgeist element to this. As you hint, the right to arrest is something which a financier might use, and I sense that the finance arrangements are much more fluid. What the borrower, the person the borrower contracts with now might not necessarily be the person taking the decisions, and there are devices which might be exploited, perhaps to have a very intrusive effect on his business. So that's my point for topicality. And I think it's also worthwhile reminding ourselves about the realities of arrest, certainly in England. We talk about it on a day-to-day basis as lawyers, but actually it's not so common. If you look, say, in England, there were in the last calendar year, 2017, there were 165 Admiralty claim forms issued. There were only 10 arrests, and of those arrests, there were only 3 sales. So it's not an everyday happening. But if it happens to you, if you're one of the 10, it's potentially ruinous. A feature of this is that it's not the sole desert or the sole punishment for a failing business. It could happen to anyone. It's immediate, and it truly interferes with your business. I don't really like analogies with other industries, but if you were a hotel and you faced a random claim, you would be very distressed if suddenly your guests were evicted and your doors closed. So it has that catastrophic effect on a ship owner's business. So again, I think that's another reason to remind ourselves what it is not, and how the balance might be achieved. What it is a very quick, simple remedy. It requires simply the presence of the vessel. There is no requirement for English jurisdiction or governing law. It just has to be a maritime claim. Procedurally, it's very easy. You don't, unlike a freezing order, have to go before a judge. You have to issue a claim form. You have to issue 2 other forms. It's relatively cheap. If you look at some of the solicitors' websites, they quote figures of a few £1,000s. What it is not is often surprising to people. An order from the Admiralty Court arresting a vessel is not an order of a judge of the court. It's an administrative order. It's not based on a scrutinized claim. It's not moderated by any discretion on the merits or the suitability of the remedy. It is not the basis of an immediate right to compensation if that claim proves to be flawed. And as I say, it is not directed against a failed business. It just requires a claim. Neither, so it is not proportionate. If you have a claim for $10,000, you can arrest and have that catastrophic effect upon a vessel worth, say, $50 million. Okay. In many respects, it's very different from the freezing order, which it's often compared with. The 2 issues which I think give rise to the debates, and which we sought to create a balance within the Alkeon, and which will form the basis of the debates in the Alkeon, the 2 elements that come up often before the international committees are wrongful arrest, and that is my point about no right to claim if the claim happens to prove to be flawed. In England, the bar is very high, and it's been restated again, that a simple failed claim does not automatically give the owner the right to recover. Now, pausing there, no one has suggested, those who are in favour of some change or moderation in the law is saying that we should do away with the right of arrest. No one is saying you should limit the rights to enforce and secure your claims. What they should do is be principled and balanced and proportionate. I think in the arrest context, the accident waiting to happen, so to speak, is that claim which is large, genuinely contested, perhaps even based on specious grounds, and falls outside the scope of insurance cover. And that is how I think an owner might be exposed. What he will not necessarily be able to do is then to claim damages, even if the vessel has been detained for many months indeed. And it's my hotel closure point. A way of moderating this would be counter-security, which you often see in freezing orders, such that the arresting party gives up, in our case, we say, an undertaking in damages no different from a party obtaining a freezing order. So, and it's on those respects that you see a great difference between the jurisdictions. In our case, a bank has sub-participated its loan, so the person who controls the loan effectively is not the person the borrower did the business with. He then goes it, and like most loans, there's a value to loan covenant. The broker who determines the value is determined by the discretion of the bank. That party goes and gets a valuation which is well below the market, accelerates the loan and arrests the vessel. Why do I mention this? Partly because it's my zeitgeist element. Those features we're seeing, there are other cases like this, are becoming more common. When we look at the discretionary element, which we invite the court to invoke on the counter-security or undertaking damages, it should be very easy for a bank to say, to give the normal wording, which isn't even a full guarantee, honouring any order which the court might make for losses caused by the owner. But it refuses to do so. So, as I say, the topical issues are, should we change the law of wrongful arrest? Should the bar be lowered, as it is in some countries? I think in Italy, the relevant test is something like beyond ordinary prudence. In England, it requires malice, and it's akin to malicious prosecution. So that would require some re-engineering of the law. Alternatively, you could balance it quite easily by obliging the arresting party, when it proves that its claim is wrong, having caused perhaps months of loss of revenue of the owner, simply to give recompense to the borrower. It's that latter point which will come before the Court of Appeal. It's one of the 2 points that will be determined by the CMI. To close, I think those who are relatively conservative on the law say that the principle of giving undertakings effectively as counter-security are so well established, the law shouldn't change. It was set, the principles were set in the middle of the 19th century. I don't think that's a good answer to ship owners who face these hazards, particularly if this sort of claim is going to be more commonplace. And I don't think a theme of this conference is modernity and change, and I don't think in an age of change we should be afraid of charting or a new course in terms of what a party who is going to invoke this draconian right has to do and what the victims' rights are.
Thank you, David. Next time I need something more hot. You know it. It was very interesting.
Well.
Yeah. Okay. Now I think we have last but very hot. I wanted to ask Mark Clough, who is a competition lawyer and a European law lawyer, something about the overwhelming role that competition is having a bit in every industry, including the shipping. But this would be too wide, so I think we have also to postpone it. And since we are in just before what is going to be the Brexit, probably, I would like to make a very simple question to Mark. How do you see the status and the evolution of the European law with particular respect on matters that concern the shipping world, at this particular time?
Good morning, ladies and gentlemen. I'd like to start by thanking my friend Francesco for inviting me to speak at the conference today. It's a great honor for me to do so because I have been to many of the previous shipping and the law conferences. And indeed, in the early days, Francesco would ask me to speak on the subject of competition law to try to terrify the audience so that they would realize, in particular ship owners, that they had to comply with competition law or be fined 10% of their worldwide annual turnover. I'm not going to do that today. I'm going to pick up 3 points that my fellow panelists have mentioned, and indeed earlier discussion, and give you a very quick EU perspective. The first one is the role of women in the world. The second is technology, and a little bit about competition law. And the final one is reality, and that might bring me back to Brexit. So women, I thought you'd like to know that the Commissioner for Transport in Brussels is Violeta Bulc, a Slovenian lady. The Commissioner for Competition Law is Mrs. Verstager, a Danish lady. So there is some inspiration for our younger women who may or may not still be in this room. Technology. I thought the presentation on technology was really spot on, thank you. I suffer not being a mathematician, but having now to understand about algorithms and how, for example, shipping lines use algorithms to, I wouldn't use the word fix, but to arrange their prices to their customers. And of course, the whole area of information exchange and data is now #1 on the agenda in Brussels, at least for Mrs. Verstager, the Competition Commissioner. And then changing gear to reality. And this makes me sad in one sense, although I haven't given up. And my first view on Brexit is that it won't happen. And I'm slightly surprised that, and I stress this, the international business community isn't doing more about stopping it. And I don't just mean those in the UK, but in countries like Italy, France, and Germany, who's trying to stop Brexit? I just ask you that question, because you're going to suffer just as much as the rest of the world if Brexit happens. And I'm going to end by pointing out how the European Commission, which of course has a job to do, has on the 27th of February 2018 published its guidance to stakeholders on Brexit and maritime transport. And I'm going to read you this, if I may, fellow chairman, as my closing piece. Subject to any transitional arrangement that may be contained in a possible withdrawal agreement as of the withdrawal date, that's the 29th of March 2019, the European Commission notice says the EU rules in the field of maritime transport no longer apply to the United Kingdom. This has in particular the following consequences in different areas of union law in the field of maritime transport. I have to turn the page. Oops, sorry. So I'll just tell you what it says under market access, because although it's directed at the UK, of course it applies also to entry into the UK as well. Intra-union shipping services and third country traffic under the 1986 regulation stipulates the freedom to provide maritime transport services between member states, as well as between member states and non-EU countries, in respect of nationals of member states who are established in a member state other than that of the person for whom the services are intended, and nationals of the member states established outside the EU or shipping companies established outside the EU and controlled by nationals of a member state, if their vessels are registered in that member state in accordance with its legislation. I'm quoting the Commission's notice, remember. And finally, on this point, it says, persons or companies who, as of the withdrawal date, do not meet those criteria that I've just read out, will no longer benefit from this regulation, notably in terms of non-discriminatory treatment as regards international maritime transport connections. So that's in the context of freedom to provide services. It goes on to say the same thing about cabotage. But as I say, whilst this is directed at saying that you in Italy can now discriminate against UK shipping interests, of course it will apply the other way around as well. Thank you very much.
Thank you, thank you, thank you. I think now you are putting the, we would like Valeria to comment. I mean, there are so many interesting things, but for her ship owners and also the only lady perspective, generally we say ladies first, but you will conclude. I don't know if you want to make any comment or ask anything in particular to one of the panelists.
Okay, thank you, Francesco. It's an honor for me to be sitting here with you. And so thank you for this second opportunity. I will be very quick because the time is gone and because I'm infiltrated here. But James, please, I have a very quick question for you. We spoke about technology. We all the time speak about technology and new technologies. And from the ship owner side, you know, we are focused all the time how to reduce our running cost, because in these difficult times is an important item for us. So in this regard, how do you see the use of technology to drive down the cost, the insurance cost for the ship owners?
Thank you, Valeria. That's an excellent question, and actually it was quite refreshing to hear Jonathan talking about mediation. You know, from an insurer's perspective, there are three principal elements to the cost of insurance. One is the claims, so any opportunity to mediate and to settle early, of course, is something that we encourage. The second aspect, of course, is the risk profile that the ship owner presents to the club. Now, by sharing information, whether it's who you trade with, what you trade, where you trade, I do see that in the future, with ship owners sharing that information, there could be some real benefits for them to see, because by sharing and providing that detailed information, it allows the clubs to better evaluate the risk profile and with that to better tailor the costs of the insurance. And I think the best example of that in the UK is with motor insurance. You now have telematics. Your car communicates with your insurer. It tells them whether you're driving too fast, whether you're driving too slow, I mean, it wouldn't apply in Naples with the taxis here, clearly, but by providing that information, the insurer should expect to receive, the insured, sorry, should expect to receive a better tailored insurance to fit their needs. And by, if they're a good member of the club, they should see with that a reduction in the cost of their insurance. I think the final element to touch on, and that is, of course, the cost of running a club. Our board at the Standard Club make it very clear to the managers that they expect to see us pushing down costs. And I think as a member of the club, you should be expecting your club to reduce the frictional cost of running its business. And with that, that includes looking at the ways in which technology can support the claims and the underwriting process, but also importantly to drive and encourage loss prevention too. And our board has promoted and ensured that we should be looking at ways in which we use technology better. And with that, they've said, look, rather than spending money on systems, look at systems that can reduce your overall cost to running the club, whether that's reducing the number of people, whether that's using technology to better evaluate risks. But we can't not turn over every stone in that process, because we understand we're a cost to your business, and in the current markets, no more than ever should we be looking and focusing on running down those costs.
Okay, thank you. But we still have insurance brokers as well. I'm
Good,
joking.
ce l'abbiamo.
Yes, too many. Joking. Thank you, James. I'd like to speak about this, but I think we have to finish. So another quick thing to speak with David, please.
I'm sure that Fabrizio is giving his time to you with great pleasure. He's a gentleman. The next section, Fabrizio.
Yeah, Fabrizio will speak about
Yes.
long
No,
session.
go ahead, please. Yeah.
Sorry, David. We know that there is a strong activity in selling and buy second-hand vessels all over the world, of course. And in this regard, I know from my broker friends that there are very specific insurance products to cover all the maritime, not all, but the maritime risks maybe related to the debts of the previous owner. I think it could be useful and interesting in this panel to briefly update us about these insurance products.
Well, that's
Thank
a very
you.
good question, Valeria, but you're probably asking the wrong person, because, and maybe James has some experience of that. It is a hazard that we see typically with maritime liens, like collisions and salvage, which will follow vessels when they're sold, and also when writs are issued just before the sale takes place. And of course, in the standard MOA, the warranty that you get from your seller is usually against a Marshall Islands seller or something like that. Personally, I'm aware of the fact that there is a so-called maritime lien insurance out there. I've done quite a lot of cases where this has been a factor, or we've tried to moderate against it. The standard advice is to look at to do writ searches, but to be honest, I really haven't seen it very active in the market. I don't know whether James, either within Charles Taylor, which is such a big insurance group, or even Federico, you might have some experience.
There is something moving in that sense. There are new products which are coming in line, which are sort of a TDI kind of cover, so basically are not necessarily linked to the typical lien insurance. They are, I would say, still a little bit untested, so we are carefully reviewing them. There are a couple of products which are being presented on the market by reliable carriers, I don't know if Lloyd's have yet produced anything like that, but certainly the Scandinavian market is offering something like that. And it is meant to be a sort of all-in, except it's a sort of expanded loss of hire, where you pick up a number of other risks, including, by the way, delay, which is probably the most important risk which a ship owner, which cannot be insured in any other way, because a non-hull related delay, which would typically be covered by a loss of hire, if it is not related, if the delay is not relating to a casualty to the ship or a peril covered under telemachinery, it wouldn't be covered. So these policies are tending to expand in that direction. We're studying them, okay?
Still studying.
I think the other way of addressing the problem is to back the seller's obligation with some sort of guarantee, but that's not something a financier or insurance company would do. So unless you have a substantial seller, it's very hard to get a meaningful guarantee. And of course, with a substantial seller, you probably don't need that protection anyway, but it's something to look at.
And for you to know, Valeria, they're not coming for free, these things.
Not for free.
Not for free.
Okay, I think we are talking about the usual question: would you buy a car from him? I think this is at the root of the problem. Anyway, thank you very much.
Francesco,
would you like to conclude?
If I may, just 1 minute.
You conclude the panel.
No, I just wanted to ask one thing. You mentioned Brexit. And say the ship owners particularly, they are continuing to negotiate contracts where, say, they have to make a choice. High Court, London arbitration, whatever it is. After Brexit, particularly for an Italian ship owner, still part of the community, is there going to be any change which needs to be considered when selecting your jurisdiction, when selecting High Court as against arbitration? Is there going to be any more difficulties, for example, in enforcing an arbitration or a court judgment after Brexit?
The short answer is no. Arbitration is outside the Brussels Convention.
Yeah.
So enforcement of arbitration awards depends on the New York Convention. Beyond that, there may even ultimately be one advantage. Not that I'm in favor of Brexit, but post-Brexit, there was a case called West Tankers, which involved Italy. There was a London arbitration clause. Court proceedings were started in Italy. The ship owner tried to obtain an anti-suit injunction in England to prevent the Italian proceedings, and the European Court of Justice said, no, you can't do that. Now, perhaps after Brexit, depending on what's agreed, of course, overall, it may again be possible to obtain an anti-suit injunction. And there's a very, very recent case, actually. High Court judge, there were proceedings in breach of an arbitration clause started in Cyprus and in Russia. And the judge granted an anti-suit injunction in respect of the Russian proceedings and said, no, the Brussels Convention had been amended. It's called the Brussels Recast Convention. And the judge ruled that didn't make a difference. Still no anti-suit injunction.
Thank you very much.
Yes, if I might a footnote to that, Federico, while the position with arbitration will necessarily stay the same because it's in the international context is essentially exported through the medium of the New York Convention, the recast Brussels is a function of our membership of the European Union. Now, non-members or those who opt out have been able historically to go into things like the Lugano and the San Sebastian. I was looking at this for last year's Shipping and the Law, and I was chatting to Chris Smith QC, who's a very knowledgeable chap here, about this. And there's been a dearth of material, and there was a paper produced, discussion paper produced last summer, which merely showed that whoever was producing that paper hadn't really engaged with the subject at all. I have not seen much at all, nor have I heard about the plans to have a convention which tracks the Brussels Convention. So I think it's a very good point, and I just think it's way down the list of priorities, and as the Brexit crisis begins to stack up, the esoterica of the conflicts of laws is not featuring high on the list of Mrs. May's priorities.
Thank you very much.
Yes, can I say
think Mario and Mark, perhaps somebody should explain what an anti-suit injunction is.
Speaking about arbitration and Brexit, I concur with Jonathan that in the immediate and in the short period or even medium period, London will not lose its pole position. Shall we consider that the London Maritime Interpretation Association has 80% of the maritime interpretation in the world? The last statistics show that reference to the London Maritime Interpretation Association has been 2,500 in 1917. So this predominance of London as a place of arbitration will not be reduced by Brexit because the awards are so-called circulating, so can be enforced and recognized abroad in other countries by a different instrument which is not affected by Brexit, like the New York Convention. However, in the long period, I don't know whether this optimistic view for the Londoners is so strong. Because shall we consider that any center of arbitration exists and has a good life if it is supported by a strong shipping community? The shipping cluster of a place can also support the suprastructure like a court of arbitration. If London might be affected in the long run by the Brexit effect, also the London Maritime Interpretation Association and London as place of arbitration can have a reduction of work. Shall we consider also that after Brexit, the parties which are not English can be somehow reluctant to agree an English law as law applicable to the contract? So this is another way that can affect also the English jurisdiction. And lastly, do not forget that exists a directive, which is the Lawyers' Service Directive, which gives the possibility of lawyers in Europe to exercise their work, their job, also in other countries of Europe. If this directive will not be effective anymore due to the Brexit, I don't know whether the possibility for barrister of English barrister to do their job in other countries, as they do a lot actually, also in the arbitration area, can continue somehow. With regard to the jurisdiction of judgments, so not awards, this is a huge problem, as a matter of fact, because the principal instrument that exists in Europe, which is the Directive 2015 of the European Union, will be no longer applicable. So this is a real great problem for the acknowledgement and enforcement of judgments rendered by an English court in Europe and vice versa, of course.
So more work for us as lawyers. I want to give the last word to Mark, please.
Sorry. Thank you, Francesco. Can you hear me?
No.
Thanks. I only want to intervene because I had the privilege of going to a meeting with the Minister of Justice of the Great United Kingdom in Brussels a couple of weeks ago, where the agenda was jurisdiction and enforcement of judgments. And I can tell you, because of course these people are hopeless, they have no agenda. They wanted to find out from the British lawyers in Brussels what the hell to do. And to cut it short, they seem to be favoring keeping Lugano as a fallback position, i.e. because we will be a third country, if there's no special deal done on jurisdiction and judgments. So that is the current complete chaos position of the British government. My second and last point is I'd like to pick up what Mario says, which I totally agree with, and that is that we already see in our work that clients are choosing not to have English law and jurisdiction. because they're very worried about the enforcement of their contracts. Now that's in a general sense, not just in shipping. Shipping may be easier to save from the London angle, but at the same time, you've got the question ultimately of the enforcement of a judgment coming out of a London court. Thank you.
Thank you, Mark. So, Federico, you want to say anything? No? Thank you very much to all of you. I hope that at the end it didn't become too technical. Thank you.